Hello? Oh, okay. Let me call to order the October 2022 Southbury Zoning Commission meeting. Meeting of alternates, everybody's here.
I guess everybody's here.
Yeah. All right, public hearings continued. North Point Ridge LLC petitioner petitioning to amend zoning regulation text under section 12, plan development to provide for design and density bonus for mixed affordable and market rate family housing.
Mr. Chairman, due to a recent ongoing business transaction, I'm going to have to recuse myself from the Northridge.
Okay. All right. You want to come back for the remainder of the meeting? We'll send you a text.
Yeah, you gotta text me.
Okay.
So, is someone else seated?
Who needs to be seated? Who's an
Yeah,
alternate?
everybody's
Everybody's
here,
here,
so we're
yeah.
good.
We're all set.
We're fine.
So who's seated tonight?
No, everybody's a regular member.
Everybody's here, I understand, but you need,
I don't know who replaces Jay. Who's the alternate? I don't even know.
There is no alt,
the regular members
He's-
are.
Jay is an
Susan,
alternate.
Susan, Dave, who.
Yeah.
recused
So Jay's the
himself,
alternate, so we're good.
Yeah, Jay's an alternate.
Richard, Wendy, and Mark. Thank you. You're welcome. Okay, thank you.
Gail, you can just hit your microphone when you're ready.
Is it on?
Just hit the button. It'll light up green. You all set?
For the record, I'm Gail McTaggart. I'm from the law firm of Secor Cassie McPartland, and I represent the applicant on a text amendment to create a mixed market rate and affordable housing under a PDD process. And I think last time, maybe your eyes glazed over with all the information that we provided, and now we're sort of doing it again. But actually, what I did is I went through the Plan of Conservation Development, looked at situations where a planning commission has disapproved a proposed text amendment and what the impact is and what your commission does in that situation, and what the statutes say about that. And I wanted you to have that because it was pointed out by your counsel that last time I forgot to mention that it will require a 4 out of 6 vote to approve the amendment because of that, which is true. So this is a little bit of a sort of a white paper, I guess, on what I want to present about all of that. I did provide to you an electronic copy that went out to you today, and I brought a bunch of extras if anybody needs a copy. It's my letter of October 11th. And let me just, for the record, say, you should have, there were some items last time that I wasn't sure you had that had been submitted. After the last meeting, I put together a sort of an update on the review that we did from a website that showed different land use regulations around the state that had some type of density bonuses for affordable housing projects. And some of those were 10%, 20%, some of them many more percentage bonuses. And also, I picked out other terms, like how many years were they being deed restricted, what's the percentage of unit, what is the density. So I wanted you to see that not only are we in line with those, but the density that we're providing here is on the low end of what those towns require for their regulations. It's a little bit difficult to do that. There's a website that put that all together, and then when you go and look at the regulations, some of those have been revised, some of them have been changed and deleted. Some have been added. They had more than one. Some of them have PDDs and incentive zones. They have both. And so I looked at some of that. I'm not claiming that I read every part of those zoning regulations that I provided to you. I just took the study that was done and tried to update it, and that's what I did. So if any of you, is there anyone that doesn't have that? Because I do have extras that I did bring along. We're okay? And it was more of a, I guess, it isn't necessary that any town does what another town does, but it does give you an idea that what sort of the range of density bonuses and incentives that are out there. So I thought it was interesting, and hopefully you did too. So I put together a letter, and I was just going to present it, and then I realized that it might have been helpful actually for you to have it in front of you. So it was emailed out to everybody, and I understand that everybody has a paper copy of it. It's always very dangerous to do a presentation to people with something in front of them to read, because you're not sure that they're going to be able to read and listen at the same time. But I think in this case, it's probably pretty important that we get onto the record and that everybody sort of have a common understanding of what this process is.
Gail, can you tell me just the date of the letter?
It's October 11th.
Okay, I got the right one. Gotcha.
So the purpose of this was to show you how to treat a zoning text application where there's been a disapproval by the Planning Commission. We respectfully disagreed with the conclusions of the Planning Commission, but you also have a right to respectfully disagree with the conclusions of the Planning Commission and approve this. And we have a statute that says that. We have a statute that says that when there has been a disapproval, and I highlighted on the second page, a proposal disapproved by the Planning Commission may be adopted by the Zoning Commission by a vote of not less than 2/3 of the members of the commission. So we have a statute that recognizes that. There's another part of that, and that is that the Planning Commission's task was to report to you whether they thought our proposal was consistent with the Plan of Conservation and Development. And the main thesis of the report was that the Planning Commission really did want us to wait and not put this application in now until there was a new Plan of Conservation and Development adopted, and then we could look at that. What I think I had said to you before is we did wait until we started last year, and we waited until the affordable housing plan was done, because we knew that was going to be, and in almost every town is, a part of the Plan of Conservation and Development once it's adopted. And secondly, because it is the topic that we're dealing with. And we wanted to make sure that we had paid attention to that. So on page 2, if you're following along, I'm just going to summarize this. So the statute expressly allows the Zoning Commission to adopt a zoning mission that the Planning Commission disapproves. And we have a lot of law and commentators in Connecticut that say that is because the Zoning Commission is the only board that is authorized to make zoning regulations. And the reason for that is that you're the people that are in tune with the community, that are looking at these issues, that understand the other zoning regulations you're made. You use the PDD text amendment yourselves, or use the PDD amendment yourselves, not the amendment, let me back up, the PDD section of the regulations yourselves. You're familiar with it, you know how it works. You're the ones that can evaluate what this is and whether it's a good proposal for the community. And our courts say if it weren't that way, then the Planning Commission would really control what the Zoning Commission does, and the Planning Commission doesn't have that authority under our statutes. The second statute that's important in this discussion is 8-2B, that states that zoning regulations shall be made in accordance with the comprehensive plan. And I point out that the comprehensive plan is not the Plan of Conservation and Development. and in consideration of the Plan of Conservation and Development adopted under 8-23. So the Plan of Conservation and Development that's adopted in this town is the 2012 Plan of Conservation and Development. It is the effective document until it's replaced. It has a 10-year life. It is at the end of the 10-year life. There's no provision in it that says at the end of the last year that nobody can bring in applications or do anything until this is done. If we did that, all during that 10 years, lots of things happen. During every 10-year period, for every Plan of Conservation and Development, for every town, there are changes that are made. Statutes that are changed, other regulations that are changed in the town that affect it. So there's a whole bunch of things that happen. It was never meant to be sort of a static situation where it had to come, for the whole 10 years, nothing new could be thought of and then not done. And our courts have said so. So number 2 on this page is this statute. Now, this statute was modified in 2021. The words were changed to say that this commission shall consider the Plan of Conservation and Development. That's what they did say. What it says now is that the zoning regulations and changes are made in consideration of. I did a whole bunch of research to find out whether that was just grammatical or whether there was something really intended to change with that change of wording from shall consider to in consideration of. And I talked to Mike Zitzka, who's one of the prominent land use attorneys in Connecticut that's written books about what's legally required and has been doing seminars for the new state statute under 8-2. And I talked to Mark Brantz, who does the same thing, and all of us have worked and done seminars at Wesleyan University and some of those kinds of things to look at. And I judged that if anybody could find something that I couldn't find, they would be able to tell me that. There is nothing. There's no legislative history on it. There's nothing that anybody knows about. They think it was just a matter of trying to make wording consistent from one statute to another grammatically. I'm not even sure that shall consider isn't stronger than in consideration of, because shall is a mandatory word. So in both cases, the commission can look at and consider. Our courts have determined what that means. That means in this kind of a setting, with this kind of an application, we can put forth and look at the different sections of the Plan of Conservation and Development and see whether we think that what this text amendment does helps to carry that out. The words for reviewing that Plan of Conservation and Development by this commission are not that it's in accord with. The comprehensive plan that is not the Plan of Conservation and Development, our appellate and Supreme Court have told us, all that means is the zoning regulations and the map. So if you look at how zoning takes place in Southbury, the zoning regulations, which include PDDs and all the other provisions, and the map, how you've laid things out on the map, is that document. And our courts have also told us that you can be consistent with that comprehensive plan, that sort of scheme of zoning in Southbury, if the provision that you approve is in tune and good for the community, the needs of the community. And that's what you do as zoning members. When you adopt zoning regulations, you look to see whether a proposed amendment is in tune with what the community needs and the needs of the community. And you do that without probably even thinking about it when zoning amendments come in before this commission. So the comprehensive plan is one item, and the other item that is looked at under the statute is the Plan of Conservation and Development. And we talked about it last time, but if you look at page 3, where I have the role of the POCD and consideration by zoning, our courts have recognized and repeatedly said that the Plan of Conservation and Development is merely advisory and that the plan itself operates only as an interpretive tool. And we have a Supreme Court decision saying that. Our appellate court has ruled that the Plan of Conservation and Development, or master plan, prepared by the Planning Commission under statute under the statutes governing municipal planning is not the same thing as the comprehensive plan. And I would point out to you that if the legislature had intended that every aspect of a plan of conservation and development had to be in accord with the proposed amendment, probably almost no amendment would meet that test. And our courts have said that is not the case. They do not use the word accord, we use the word consider. Bob Fuller, who writes the textbook on land use law and practice, explains that when exercising its zoning powers, the zoning commission is not controlled by recommendations of the planning commission. You do put those into the record, they're read into your record, and they should be considered. I'm not saying that they should not be considered. I'm just saying that this commission gets to be the ultimate decider of that. He states that if the effective recommendations of the plan of conservation developed where they exist are merely advisory. And then if you keep going, there's a third statute. There are several new statutes that are important here. Your commission now has, and I know your overall review of your regulations is going to make some changes because of the changes in 8-2, which is the Zoning Enabling Act for the state of Connecticut. And when they do that, you're going to be looking at some of this. But some of these statutes, they are effective now, and they absolutely control what this commission, when it provides for zoning amendments. And I want you to take a look at it. So on page 4, number 3, I'm setting out what those statutes say. So those statutes contain provisions that authorize multifamily housing using a planned development district to provide inclusionary zoning for multifamily housing with a density bonus, affordability component, and a protection of historic factors. What I just wrote in that one sentence is what all of these new statutes say. So they provide exactly what we proposed. They provide multifamily housing using a planned development district to protect inclusionary zoning for multifamily housing, it should be housing, not hosing, excuse me, with a density bonus, affordability component, and protection for historic factors. Look down below and you'll see what the statute says. The statute at 8-2B says it's to protect the state's historic, tribal, cultural, environmental matters, and this is a shall. The zoning regulations shall do these things. These are mandatory. Provide for the development of housing, number 2, provide the development of housing opportunities, including opportunities for multifamily dwellings, consistent with soil types, terrain, infrastructure, for all the residents of the municipality. And we have an affordability plan that tells us that over 30% of the people in this town would qualify for the medium income, low income affordable housing. Promote housing choice and economic diversity in housing, including housing for both low and moderate income households. Our proposal is to provide 20% of those units to be deed restricted to do just that. And then there's some footnotes here because I'm telling you what the statutes, how the statutes were changed. But there is a statute that was in effect in 2012 when the Plan of Conservation and Development was written last time round. And that statute said that that plan shall make provisions for the development of housing opportunities, including opportunities for multi-family housing. And the second part of it is to promote housing choice and economic diversity in housing, including housing for both low and moderate income households. So it's not new. Even in 2012, the Plan of Conservation and Development had to do these things. And guess what? On the next page, the new statute for the Plan of Conservation and Development says exactly the same thing. So both this current 2012 Plan of Conservation and Development that we're looking at has those provisions, and the new one must have those provisions. So there's going to be no gap between those goals. And I think it's interesting that both of those, what the statutes must provide and what the plans of conservation and development must provide are completely in sync under the statutes. So we see that that the regulations will expressly allow for development of housing which will meet the needs, the housing needs identified in the state's consolidated plan. That plan of conservation and development tells us that the state's plan is to provide this kind of diversity in housing and multifamily housing. And then the word inclusionary may not be in everybody's vocabulary, and the statute that talks about inclusionary zoning also does define it. So a municipality having, we have a statute 8-21 that says that a municipality having zoning authority may by regulation of the body exercising zoning authority, that's you people, the zoning commission, you can implement inclusionary zoning regulations, requirements, or conditions. It defines inclusionary as zoning, as any zoning regulation, requirement, or condition of development imposed by ordinance or regulation which promotes the development of housing affordable to persons and families of moderate income, including but not limited to the setting aside of a reasonable number of housing units for long-term retention as affordable housing through deed restrictions or other means, and the use of density bonuses. So we have a statute, 8-2I, that says to this commission, you have authority to adopt such a regulation, and that is independent of all these other statutes and regulations I've been looking at. So you can, it allows you to do it, and notice the density bonus, and notice that it also will allow for the long-term retention. Both of those are part of the proposal that we presented. And then there are some things that, there are some, in the new statute, there's the shalls part of the statute, which are the things that are mandated, and those are started on page 4. So that's provide the housing, promote housing, preserve state historic. There's some other shalls in there that don't have anything to do with our application, but these are the ones that I picked out. And then there's also mays in that statute. Zoning regulations may do certain things. And then there's a section that says zoning regulations may not do these certain things. Congen Stat 8-2I does the inclusionary zoning. 8-2G provides a format for zoning regulations to provide for a designated number of permitted multifamily units in excess of applicable density limits where deed-restricted affordable housing is provided. So we have another statute that says you can do, this commission can have a regulation that does precisely what we're talking about. They're making very sure that there is an ability to have an exception to density limits where this kind of housing is being provided. So we have another statute that authorizes and indicates that that is an acceptable accomplishment for a zoning regulation. 8-2C provides regulations may, and here's a may, and guess what's in there? Planned development districts. So for the first time, there's been case law in Connecticut that has upheld planned development districts throughout in different places in the state. But the statute was changed in 2021 to say you can provide for floating zones, overlay zones, and planned development districts. So we provided a proposal that does the things that were established as authorized in these statutes from 2021, and that is a density bonus, a restricted, a set number of affordable housing that has to be provided, that we're using a planned development district to do that, and the authority is all here to do that. So what I'm trying to say is the regulation that we provided not only met the requirements before the statute was passed, these statutes expressly permit what is being proposed. Okay, and then because the Planning Commission, because you have there is a requirement that you consider the plan of conservation and development. I wanted to show you that what we proposed is consistent with many provisions of the plan of conservation and development, including its overall goals. There is nothing that says that we have to meet every word of it. As you just saw, the statute doesn't say that it has to be in accord with, it just says you have to consider it. And our courts have said consider means at these hearings that we're in right now, that we're gonna go through it and take a look at it, and it's gonna be out there on the table for consideration. So I went through, and the reason this is long is not because I wrote so much, but because I have quoted sections of the Plan of Conservation and Development, and then I have a response to each one about how I think that is consistent with what we have presented. So I'm saying to you that even though the text amendment need not be in accord with the POCD, the zoning commission can and should find that in consideration of the 2012 Plan of Conservation and Development, that we have met that requirement. The first one is that the amount of land consumed by new single-family houses, and this is back in 2012, by the way, the amount of land consumed by new single-family houses could alter the town's character and affect natural resources. Alternatives are multifamily dwellings, condominium or rental, which can provide lesser cost dwellings. It's a quote. It's a long section. I didn't quote the whole thing, but if you want to look at it, you can. My response is that the Plan of Conservation and Development recognizes alternatives to single-family dwellings are needed and states, quote, alternatives include multifamily rental units which can provide lesser cost dwellings. That's what we proposed. B, at page 12.5F, the following are excerpts from this page, and there's a whole bunch of lists of these. I took each one and put it in italics and quotes and then responded. One of the goals is to consider alternative forms of residential development in clusters of single-family or attached units when all of the following are met. And then we're going to go through what the following are. And our response is that the POCD recognizes alternatives to single-family dwellings, this we just read, and they can include multifamily. The PDD text amendment goes even further and provides an alternative that deed restricts units, restrictive units provide for lesser cost dwellings. So we are naturally, there could be some natural affordability by having 1 and 2 bedroom units, but there's also restricted affordability because we're proposing that 20% of the units have to be deed restricted. Consider, this is a quote from the plan, consider multifamily dwellings, not age restricted. That's what we have, no age restriction. And then it says, in a number not to exceed 220 to the year 2022, when all of the following are met, and subject to periodic review, up to 30% of the 220 may occur as units in those clusters or groups of multifamily dwellings for the purpose of maintaining a balance of housing opportunity reflecting family size, income and needs of young families, single persons, and single-parent households, which balance is reasonable if spread over the planning period. Well, some of that is now illegal. The idea that we're going to have housing for young families, single persons, single parents, all of that kind of thing. And we've also added workforce, seniors that want to stay in their own community, all of those kind of things. Those are consistent with what we provided. So our response is that the 2022 has arrived, and so the statute now provides that zoning regulations shall not place a fixed numerical or percentage cap on the number of dwelling units that constitute multifamily housing over four units, middle housing, or mixed-use development that may be permitted in the municipality. And down in the footnote, I'm telling you what the statute means by those. So multifamily housing is a building that contains, in one statute, it's a building that contains 3 or more units. Middle housing is duplexes, triplexes, cottage clusters, and townhouses. In other places in the statute, it has set a a threshold at 4 or more units. But in the Plan of Conservation and Development in Southbury right now, the 2012, when you go to the guidance document that's stuck on the end of it, Supplement B, it's 2 or more. And it uses the word attached. So attached units, units that are attached, are considered multifamily. It doesn't use the word multifamily other than multifamily development groups. And those are 2 or more units or duplexes. So they're small, small buildings. And we'll talk about it in a minute, but there's a limit at 2.6 of those per acre. You can have 1 per every 15,000 square feet. So I'm at, right now where I am is at BA on page 6. We're getting through it. So we have a zoning text amendment that says we can't have those kind of limits, are not allowed any longer in Connecticut. So the text amendment that we provided, when we looked at that, we eliminated the requirement that it be consistent with that requirement and the other requirements of the supplement, because the supplement to the Plan of Conservation and Development, taken as a whole, is not doable under the state statute today. So we have, for this new class of PDD, does not meet these requirements. However, the text amendment is responsive to the Plan of Conservation and Development, acknowledged lack of dedicated affordable housing in Southbury. So we recognize, the Plan of Conservation and Development recognized in 2012 that there was only 1.14% of Southbury's housing was classified as affordable. And there's a little bit more now, but not much more. And that's CHAFA financed housing, and it is also deed restricted. Southbury does have a lot of what's considered naturally affordable housing. Some of Heritage Village is that, not all of it. But there's no deed restrictions on those. The page 3-13 of the Plan of Conservation recognizes that it is not reasonable to expect Southbury to achieve the 10% goal in the next 10 years, yet it's important to continue to provide a range of housing types for all ages. So the plan does look at, the Plan of Conservation and Development in 2012 does look at a need for this, and it does set out that it might be difficult to meet that goal, but there needs to be a range of housing types. So this is precisely what the text amendment does. So the text amendment's not inconsistent with those goals of the Plan of Conservation and Development. Further, the text amendment at 12.13 expressly acknowledges consistency with the Plan of Conservation and Development goal of providing diversity of housing types and providing additional housing opportunities in compliance with 8-2. So we're doing those things. Plans of conservation and development, and I think all of you understand when I talk about the 10%, that 10% is the goal for towns if they don't want to be subject to the affordable housing appeal process, which is the 830G applications where somebody comes in and they might have a nice plan, but they could have a really lousy plan, and as long as they can get sewer and water, they can do it. You can't say no. The burden is on the commission to, if it turns down one of those, to show why it's turning down. If you're under 10%, our courts have said you're assumed that you need affordable housing in your community. So that 10% is an important number. So, and then I'm saying, and I think I'm right about this, that certainly a zoning amendment is not appropriately denied because it complies with the current statutes, but not the POCD recommendations. If it fails to comply with something that's in the POCD, and the only thing that I can really think about is mainly the supplement, which is a guideline. If you denied it because we said we couldn't comply with it because of the state statute, I think I know how that would turn out. So I found no authority to allow a denial on that basis, where you're complying with the state statutes, and the Plan of Conservation and Development is indeed outdated and doesn't meet that. But the Plan of Conservation and Development does have broad goals for affordable housing, the need for affordable housing, and all of that is there. and we are carrying out that goal. The next item in the 2012 plan is site design and architecture are considered with the appearance of the single-family and rural character of the town. The new statute at 8-2D provides that zoning regulations shall not be applied to deny any land use application, including for any site plan approval, special permit, special exception, or other zoning approval on the basis of a district's character, unless the character is expressly articulated in such regulations by clear and explicit physical standards for site work and structures. So every zoning commission in the state is now looking at the provisions that we have in our regs that say that, mostly it's special permits that have to be consistent with the character of the neighborhood. We have to define exactly what that is. And, but we're saying that's true, but our text amendments take that into consideration. We take into consideration that this commission, because it's a PDD, can look at the architecture and they can be sure that it's protective of the neighborhood. They can look at the forms of the buildings, we have said in our text that we put in that they have to be appropriate for historic New England landscape with gabled roofs. So there, now you're looking at something that's an actual structural definition of character. So we did this. And that they complement the building in terms of style, detailing, and materials. We also limited the stories to the same number that are allowed in the residential zone. We put a 300-foot setback from historic districts because the Plan of Conservation and Development says that these should not be, should be located, by the way, on main roadways or near main roadways. That's what your plan says right now. That's what our text amendment says. But it also says that there shouldn't be in the district, and we're putting ours, we're going further and saying it has to be 300 feet setback. The district, I think all of you know, is a 200 feet from the road line. So district, depth of the district is 200 feet. So we're going 300 feet. So we are definitely doing that preservation. That goal is also reflected in the Appendix B guidelines that provides for screening of improved areas, parking, and buildings from public ways. Our text amendment, when you look at it, provides for screening. We have screening so that when you drive down the road, you'll be screened from the roadway and not see that. And this will be both, whether or not it's in a historic district. It is noted that Appendix B provides, secondly, the intent of the plan is to disperse such housing geographically to avoid a concentration which would alter the traditional residential and rural character of Southbury. I guess I live in this community and this matters to me a lot. And that is that we don't get into a situation where everybody that's in affordable housing is sitting in one little section of town. I would so much rather see it dispersed, and I was amazed to see that our 2012 Plan of Conservation and Development actually says this. It says that we should do this, that housing should be dispersed geographically to avoid a concentration. And this type of PDD allows this commission to say, okay, we don't want to put all of this in one spot. If you're going to come in with one of these, we can take a look at it. It's not just taking one section of town and saying, okay, you can put this in that section, and this is where all of this will take place. So I think this was another interesting point that's in the Plan of Conservation and Development that we actually carry out with the text amendment. And then the Plan of Conservation and Development in 2012 says dwellings occur in small separated groups so as to avoid a mass of buildings, and so that groups of dwellings do not become a pattern or concentration of development along a public street. So the response is that 8-2B states that zoning regulations must provide for multifamily housing, but the definition for multifamily housing found in the Plan of Conservation and Development is different than that that's in the state statute. There, multifamily housing is defined as attached units 2 or more, but the density is limited to 1 per 15,000 square feet or 2.6 per acre, which we've talked about. Appendix B does provide, and I quote it, The recommendations of housing and residential areas of the plan identify additional attached dwellings, not age-restricted, as a means to provide housing opportunities in Southbury. So it isn't a carte blanche that on that Schedule B of what's there. It is one model of how in 2012 it was determined that this kind of multifamily, which for them was 2 or more units, would be. The POCD at page 12-4 acknowledges that alternatives to single-family houses may be particularly important to meet the needs of young adults and empty nesters. So there it is. In the 2012 Plan of Conservation and Development, we're looking at the kind of 1- and 2-bedroom housing, rental housing, that we're proposing. So that's exactly what we're proposing. Also note that nothing in the Plan of Conservation and Development deals with density bonuses to incentivize affordable housing, which is within the diversity of housing type goals of the Plan of Conservation and Development. It just wasn't, it's just not found there. We have a state statute now that says you can do it. The fact that this positive approach is not mentioned does not mean that a proposal for a 1- and 2-bedroom rentals is not a positive alternative. Thus, the Zoning Commission, in considering the POCD, should find that the proposed alternative is consistent with the Plan of Conservation goals, even given the Planning Commission's report. The next statement from the plan is that sites are not within or its sharp contrast to, I think it should be in sharp contrast to, established single-family house neighborhoods and buildings and parking areas are buffered. So our response is that the text amendment places the affordable and market rate units on or near major roadways, which is, by the way, recommended in the Plan of Conservation and Development, and I cited the section above, and provides excellent buffers for buildings and parking from roadways. See our proposed section, 12.46, for that same requirement. Except for commercial areas, almost all the major roadways in Southbury are R60. So we have a Plan of Conservation and Development says these should be located on or near a major roadway. The major roadways in Southbury are zoned R60. Our regulation proposes these for R60, for that R60 zone on the major roadways. And I think I said to you before, we chose R60 and did not go out to R80 because we felt like that was a more country-type location, and that if we're on major roadways in R60, it'll be more consistent with this kind of housing. The building coverages are similar to the underlying zone. There's buffering. The number of stories is similar to it. So it's not, quote, in sharp contrast to the single-family location. There is assured provision. One of the requirements is there be assured provision for water supply and sewage disposal that precludes any likelihood of a need for central public systems. And in this regard, community systems of water supply and sewage disposal are to be avoided. So our plan is that the water and the sewer have to meet, for anybody that comes in with this proposal, have to meet the public health code. And the public health code in Connecticut is strict and is that's where the authority, health districts and the state health are where the authority is for reviewing those and getting that right. So I can tell you that anybody that's going to do one of these developments isn't going to come first to you. They're first going to go to an engineer and see whether they meet the health code and what that property can support. So the proposed amendment does require that it meets that health code. Density of the next statement of the 2012 POCD is that density of units on a site does not exceed its development capacity. The rural character of the site design and architecture are consistent with the appearance of a single family and rural character of the town. Okay, so our response is the text amendment recognizes development capacity by excluding wetlands, watercourses, 100 and 500-year floodplains, steep slopes from the available acreage and density. So we did that. The section of our regs for you to look at that does that is 12.6.4.2. The Plan of Conservation Development at page 12-7 says, continue to support a variety of means that may lower or mitigate rising housing costs with regard to modified road and subdivision standards and manufactured residential dwellings. Okay, so what we're doing is we're putting together a text amendment that will allow to address the rising housing costs. It does that part. POCD page 12-8 suggests identification of location where multifamily houses may be sited in a manner consistent with neighborhood while maintaining a rural character of the town. And it also says update zoning and use other mechanisms for determining the location and standards. Update zoning, that's you, update the zoning regs, and other mechanisms for determining the location and standards for residential clusters and multifamily dwellings with predetermined criteria and guidelines. So after 10 years, this hasn't happened here. However, the zoning text amendment includes predetermined criteria for density, coverage, height, all consistent with single-family R60 zones. Further, the recommendation is consistent with the proposed zoning text that locates multifamily, mixed affordable, and market rate units on or near major roads. And as to character, it provides the 8-2 says that zoning regulations shall not do that, do not talk about character without saying what it is, but we did provide precisely the kind of character that we're looking for any proposal that comes in under this proposed provision of the PDD text, which is that it will have this New England character, which is identified by gable roofs and so forth. So we have set down some standards. Page 12-8, update zoning and use other mechanisms. The response is the petition is consistent as it provides other mechanisms for determining location and standards for multifamily development, which is the PDD amendment on major roads or near major roads, which is also consistent with the Plan of Conservation and Development. And then there was a provision that says, continue to use Appendix B, technical supplement to evaluate and consider proposals for multifamily development when it meets the criteria defined in this plan. So that's the part that we can't do, but the part that we can do is all these general major provisions of the Plan of Conservation and Development. Section 17.4 says that it talks about consistency with the state and regional plans, and these, of course, were the state and regional plans at the time. Per 8-2, zoning regulations shall expressly allow the development of housing which will meet the housing needs identified in the state housing plan to address significant disparities in housing needs and access to educational, occupational, and other opportunities. So there were state growth principles, and the Plan of Conservation and Development was required under the state statute in Connecticut, in Southbury and other places, to put directly into the document if there was anything that was not in that plan that was not consistent with the state's plan, and also with the regional plan. So here's the principles that were picked out when the 2012 POCD was written. It said expand housing opportunities and design choices to accommodate a variety of household types of needs. And then Southbury said that their plan was consistent with that goal because it offers a wider range of housing types than neighboring communities, and that Southbury will continue to do so, and that the POCD supports the continued allowance of apartments and apartments above retail and accessory units. And then the other principle from the state plan was to concentrate development around transportation nodes and along major transportation corridors to support the viability of transportation options. And the plan said it was consistent because Southbury's development patterns are arranged by and guided by major transportation corridors. That the Plan of Conservation and Development continues this by planning for future development along and near major roads. So the Plan of Conservation and Development in Southbury says it's consistent with the state plan because we also look for development along major roads. This development that we're proposing is along major roads. The response is that the text amendment both expands housing choices in Southbury and puts the proposed mixed affordable housing, multi-housing along and near major roads. It meets the standard of the POCD and the state plan. And then the second part of this is that the town's plan of conservation development had to be consistent with the regional plan. And to that issue, it says that the regional housing plan supports a, quote, increase opportunities of affordable housing, promote a variety of housing types, and that this is consistent with the plan of conservation and development as the POCD supports a continued supply of diverse housing types. So this is the plan talking about how it is consistent with the regional plan and saying that what our plan does is it supports a continued supply of diverse housing types and that it also supports an increase in opportunities for affordable housing. That's what we're doing. So 20% set aside de-restriction housing required by the PDD text does just this. And then the next, I guess in the last issue was, again, the need to wait for a new POCD. I did look again to see whether there was, because of the planning report, to see if there was something I'd missed on some reason or any court cases where any court had looked at it and said, we tell people they have to hold back until a new plan is adopted. The PDD zoning regulation right now refers to the adopted, it says plan of development, but plan of conservation and development. And then I did make one little change throughout your document because I couldn't help myself, so that you didn't have to repeat that every single time. So when it says POCD, it means the adopted one. So from time to time, when you read the zoning regulations, it's whatever the adopted one is of that time. Zoning regulation might go on for 30 years, and there might be 3 plans of conservation and development during that 30 years. So no matter what the POCD will provide, the POCD pursuant to 8-2 provides that section C1, that the plans of conservation and development shall do these things. And this is sort of repetitive from what we did at the beginning, but I'm pointing out to you that it says that the plan of conservation and development must provide for the kinds of things that we are providing for in this text amendment. It's almost impossible that our text amendment wouldn't carry out the goals of that plan of conservation and development, which by its own statement says it does comply with these goals. And those goals are to promote housing choice, including housing for both low and moderate, and also for opportunities for multifamily housing. The current POCD at page 1-3 highlights the then current provisions of 8-23. 8-23 is the statute that tells the Planning Commission what has to be in the Plan of Conservation and Development. So after doing this, and it's tedious, but our job, one of my jobs was to show you that we proposed a text amendment that could, when you considered the Plan of Conservation and Development, you would be able to say, yes, this does carry out those goals of the Plan of Conservation and Development. And in order to do that, I could have let all of you go through it all, and I thought I'll do that instead. So we were very aware at the time that we drafted it that there was no way that we should start an amendment that would pick up anything that was not allowed by the state statute. There's just no way we could write that. And I couldn't have done that next year or this year. And I really don't think this zoning amendment that we propose would look very different than if we did it now or did it next year. Because what we're doing is carrying out those very broad goals of the Plan of Conservation and Development that it must have based on the state statute. And also we're carrying out the broad goals that have been thrust on every zoning commission in Connecticut, which is yours. Okay, but I think as I said to you, we did look at it doing incentive zones and different kinds of ways to do this. And I just, after, I guess it's been now almost 30 or 40 years of experience in doing land use, and both in the town of Southbury and in many, many towns that I've represented, and towns that I've appeared before, and all those years, I think one of the best things Southbury has is the PDD process. It works. It gives you discretion. If you hate the project, you can just say no. We have a state statute that says when you turn down a zoning amendment, you don't have to even say why. I think you should, but, you know, but if when you approve it, you will tell that you did consider it, and there are some sections of the Plan of Conservation and Development that are definitely articulated and carried out through this. And also, it's consistent with the new zoning that is looking at density bonuses and looking at inclusionary zoning, and all of those goals that are set out. When I talked to Mike Ziska about the Plan of Conservation and Development, and whether, because the planners have, for years and years, have wanted to get a state statute that said that the zoning commission could only pass zoning regulations that were consistent with the plan. But a couple of problems with that is that the plans are 10 years. And they're a lot of work to do those plans, and I really do respect the job that the Planning Commission does in putting all those surveys together and doing all that work to try to figure out, you know, what is it that is special about Southbury? What are we trying to preserve? What's important there? But it also, so in that conversation, I tried to figure it out, and they said that there was a huge lobby in the legislature to try to get Connecticut to open up to do more kinds of housing, more affordable housing. Some of us felt very protective, I did, about what's special about our communities, and we didn't want to lose that. So we want to provide affordable housing. We don't want to lose what's special about our communities. And I just looked at it and figured out that the Planned Development District way of doing this would work. And what Mike Ziska said is he thinks that what will happen if this were to ever be tested, and I'm not sure it would be, by the way, but in this situation, but if it were ever tested, that a court would be more likely to look at any provision that carried out sort of the general overarching theme of the change to the 8-2 statutes was to provide for more housing. So when somebody comes in and provides more housing and then tries to say, well, it didn't meet this particular test of the Plan of Conservation and Development, he doesn't think that's going to work. So I think that the theme of the statutes, the theme of the Plan of Conservation and Development, the theme of our zoning, our zoning amendment, all match. And I wanted to set that out because it was a lot of work, and you can take a look at it and see if you agree, but I think this commission has everything it needs to approve this. Now, the other thing, I hope that you've taken a look at the amendment, because the amendment does not say that there's no consistency with the Plan of Conservation and Development. It says it doesn't have to be in accord with that supplemental plan because of the reasons I've said. It doesn't comply with the statute. It doesn't even provide really multifamily housing, in my view. But it does say that if a new Plan of Conservation and Development comes along and an application comes into you for one of these PDDs, that you get to look at whatever plan is available at that time. It doesn't say that you're not looking at that plan. And when you look at that plan, you're going to see a very substantial incentive and goal to get Southbury to produce some different kinds of housing. Okay, I think I've probably said enough. I just want to make sure you have some things in your, I know you're probably got enough paper and we've killed enough trees, but I was worried last time because I thought you didn't get some of the things I had sent that have been, they started with the planning and I asked that they be copied to the zoning commission so I didn't have to rewrite them and redo that. You should have a memo from me that's dated September 14th. That was the response to the SLR report. And I presented that last time. And if anybody doesn't have it, I have extras. You have one? Yep, okay, great. Okay. And you should have a letter that was dated July 7th and revised to September 1. It was addressed to the Southbury Planning Commission, and it was an overview of the PDD text amendment in conjunction with the zoning commission referral. You should also have that. And then we provided a memo that went through the affordable housing plan and discussed how it was consistent, the affordable housing plan, and showed how it was consistent. Actually, I think that memo is the one that's July 7th revised to September 1st. So that one one of them deals with the affordable housing plan, not just the plan of conservation and development. It goes through the different objectives. Because one of the, I guess I can call it a criticism or observations of the Planning Commission was that they didn't think that we met the objectives of that plan. And the objectives of that plan are pretty much deal with setting up a committee and having the committee determine where in Southbury there should be this kind of housing, what the areas are, doing some studies, putting that together. But I didn't ever think that those objectives said you couldn't do what we're doing here. I mean, I didn't believe that, and so I went through that plan and reviewed that plan. So there are objectives there, but a lot of them just don't have anything to do with private market type developments where a developer comes in and spends their own money and does that. So when you read through these objectives, you'll see a lot of them are sort of governmental. I wasn't sure whether Southbury wants to fund those kind of things, how they will get funded, where the funding will come from to do those. But there's a good reason for market rate units to come in, that people pay taxes. They're usually become vibrant parts of the community, both economically and otherwise. And I never thought that they were mutually exclusive. I never thought that the town couldn't have a program, housing. There's been partnerships in housing that have been done with Grace Meadows and some other projects that are fabulous that I've worked with. And I just think they're part of the choices and the alternatives that there are. And this is another alternative. Now, the other thing that will happen if this PDD text amendment is approved is that whoever comes in, whether it's my client or some other client, is they're really gonna have to come in and give you architectural plans. They're gonna have to do all those things that a PDD requires. They're gonna have to really show creativity, show design merit, landscaping, all the kinds of things that I think have made developments, PDD developments in Southbury so valuable. So, they're, and with the 20%, there's an incentive for people to do this. At 30, if you go to 30%, and I know we're not looking at dollars and cents, but that anybody that does a development, if they don't make some dollars, they don't do the development. So if you're gonna do that, then the quality, I think, will be very much affected. I think that the 20%, one of the things we looked at really carefully is could we, at 20%, produce in Southbury a quality project and do all this kind of review, all the architecture, all the kinds of things that need to be done to make that a quality development. And that was sort of where the limit was. So beyond that, you could get more housing. You can throw out the zoning regs and just get it approved, as long as you can get water and sewer. But the design criteria, as long as you're not treating the affordable units any differently than the other units, they're all have to be about the same. That's what the 8-30G does. I represent towns, and I just cringe when someone comes in with one. I mean, they can work out, and there have been small projects in Southbury that have worked out, but there's no certainty with that. So that's the reasons that we did this, and I think you may have some questions, or maybe I've completely, maybe your eyes have glazed over again. I hope not. there anything more you want to say?
No, I'm okay for right now.
Either, Mark?
I'll leave my comments for
Okay.
I just wanted to point out to the chair, if there were no questions at this time of the applicant, that SLR is here. And they have advised both planning and zoning and are acting as the town planning, probably heard at some point, and members of the public here. And then if you're gonna continue the public hearing, you may wanna discuss whether there's any questions you want me to address. And listen to a lot of the legal argument, but I'm not here to advocate for or against, but I am here to answer any legal questions that you're going to have.
So at the very end, Attorney McTaggart, thank you very much for your presentation. You mentioned that you had put a lot of time and effort into the 20% versus the 30% being some sort of breaking point. Have you got a reference to other projects that you've seen historically didn't make it at 30%? And what would you get?
We started,
How much time on it?
we started at 10%. So the rate, when we first started, we came in at 10% because we knew that 10% would work, and you could look at the dollars and cents and see how that would work for, in today's building costs. But I can
You're
ask,
doing the sales approach.
yeah, but the sales approach sort of isn't a zoning use question, but,
You're using that as a justification for why you're going to 20% as opposed to 30%. And I'm wondering how you arrived at that difference.
okay, well, I think actually Mark did explain it
I think
last
there's a
time.
very simple
Yeah.
answer to that. Mark
Okay.
Feinkorf for the public record, civil engineer, land surveyor, working with Gail, and my client, Mr. Darby. You go to 30%, there's no reason for us to be here. There's none. We just go straight through 830G and don't and bypass the whole system.
Okay, so what's the model or the economic analysis that you base on? Is there something I can refer to, or is it, I just take your word, and how do I check this?
Well, so when you look at 830G,
Okay,
from affordability standpoint, you do not, every one of those units, you make it, you're on a loss. Okay? You lose money on every 830G affordable housing unit because you're talking about market rate at 80 or 60% of the affordable component, what they consider as the affordable level in that town or in the municipality. So you make no, so those units have to end up, the market rate units have to supplement those units. So as, like anything, it's dollars and cents. The cost of construction versus how much you can get for rent. So if the rents on those 30% are losing money, then you have to make it up on the market rate. And the market rate is dictated by the market. You can't over-expend dollars at a market rate, so you end up losing. There comes a point where the pro forma on the financing doesn't work. And the only way you get around that is density. So I can tell you, I'm working on a major project in Bridgeport. It's over 500 units of affordable, and 30% of it is affordable. That's what it took for the developer in order to make the money to pay for the losses on the affordable units. So its density ends up being,
so at 500 units,
yeah,
30% starts to be viable.
it's been over years, I can tell you, we've been working on it 10 years, okay? So it's not something that happens overnight, but
Asking, you know, how you
No, it's a
arrived
good,
at that.
it's a good question, and I think at the were you at the last
Yeah.
hearing?
No.
Okay,
Yeah.
so, Mark, why don't you, Mark does build, he is a builder, and he does build houses. He isn't altruistically coming in here and,
I'm happy if you say to me, look, we tried 20% in this place, and it was this many units.
he did,
and
he
it
ran
went-
the,
It went belly up.
oh,
And we tried, we've got one now that's at 500 units with 30%, it looks like it might make it, just so that I can kind of understand how you're arriving at.
well, we arrived at the number by looking at the experience that our client has had with construction himself and how much it cost to do the construction. And then if I had 10 units affordable, and they're gonna be at the medium income for our region, which is set through the HUD numbers, and we set those numbers, and we can only rent those at those rates, then what do I have to rent the other units at? And there's a market for those units that works out. And so, I'm not the expert on this, but my client is, and we started at 10% because we knew it was realistic. The SLR made a recommendation that we look at, see whether we could do 20%. He did a really hard look at that and decided that he could do 20%. If he could do it, somebody else could do it, probably too, and still make it work. But he is losing a bunch of money each time you're putting affordable housing units together, because those other units are subsidizing, but there's only a limit to the amount they can subsidize, because the market sets the rental rate. So, did I explain that right?
That's correct. And just.
Can I,
another-
let me let him do it, because he's, let me just answer.
Another question.
Okay, I'd like him to, Mark, I'd like, another Mark, I'd like him to answer the question.
We ought to all get in the same
Yeah.
room together.
Mark Darby, North Point Ridge, just for the record. Two components here are being discussed, where at 10%, it was affordable for the developer to still have market rate units cover the affordable units. So if we were to use a number of 500, that development probably started at 100 units. He had to go to 500 units in order to oversize the 830G. Now, he could do that because he had municipal infrastructure. In Southbury, we have no municipal infrastructure. The only thing we have is public water. We don't have any public sewers, so we're dependent on septic systems. The septic system is a determining factor on any building parcel here in Southbury. So, that being the case, I was able to increase from 10% to 20%, but that's really my maximum limit I could go, as far as incorporating affordable and market rate units to cover one another. I can't increase the project because I have no municipal sewers. So this guy here, who started out 100 units, he could go up to 500 units, he can maybe even go up to 1,000 units. He can go, 20 stories high. He can, in certain municipalities, you can't do that because you have municipal sewers.
Well, we also, when we went up to 20%, we kept the density the same. So when we increased it to 20%, we had a density of 10 units per acre, and that acre is after you got rid of the steep slopes, the wetlands and so forth, so it's a buildable acre. And we ended up with keeping that 10%, and that was really Southbury-centric. We just really we felt like it was trying to, I know we're not supposed to use the word character, but trying to think about the sense of place that Southbury has, and make it a project that everyone will be proud of, and will fit well into a neighborhood. So we kept that. We didn't go to some of the towns, a bunch of these towns. They went up to more than 20 units per acre. Some of them are 30, some of them are more, a lot of them are taller. We didn't do that, and they're not all large towns, by the way. They're not every one of those towns that, in that study, they're not all Bridgeport and New Haven and Waterbury, they're not. So, I don't know if we've answered it well, but it is true that the 30% number is a tough number too. I get that.
Thank you.
Did you have another question?
I did not. Thank you so much.
He doesn't want to hear more.
Anybody else have any questions? Does the representative from SLR want to say anything?
Yes, I do. Thank you.
Hi, good evening, everybody. For the record, my name is Robert Collins, and I am a consultant planner for the town of Southbury with the firm of SLR. I think it's important to make sure that that clarification is made, because in many cases, they've been referring to SLR as if we're some kind of entity, but we have been hired to be your town planner currently as a consultant. And so we're representing that point of view, not some other opposition point of view or something like that. The other thing that I think is important for me to make, I want to just make some opening statements, is that as the consultant town planner for Southbury, I really am, I have two hats tonight, because I am representing the Planning Commission because of the work that I have done with them, and Richard Tirdo, the chairman for the Planning Commission, is here as well. And so I am representing their review and the review that we helped them do on this application. But in addition, as the consultant town planner, we were also asked by your chairman to also review and give you a recommendation based on our professional planning experience. So there's two slightly different hats there. One that's more focused on the Planning Commission and what they were going towards, and the review of the POCD, and then more from the zoning side. The other thing that I think is very important to mention as an opening statement is that there's nobody in this room, or that I know of at least, that is really not suggesting that affordable housing isn't a very important issue for the town. I think that answer has already been made, because in the last 6 months, at the beginning of this year, there was an affordable housing plan that the town worked on through the Planning Commission with my assistance. And we involved the public in developing that affordable housing plan, and it was ultimately adopted by the Planning Commission. So I think that is a question. As a matter of fact, the applicant and some of their representatives also participated in that process. And I think it's very important to make sure that it's understood that we all obviously are supportive of affordable housing and want to advocate it. However, the Planning Commission did complete their study. They did interact with the public as well as the applicant, and they ultimately came up with 6 strategies that were made that seemed to be the best strategies for the town for the next 5 years that are in the affordable housing plan. And those strategies are the ones that the Planning Commission is now pursuing to help bring more affordable housing to the town. One of those strategies is a housing overlay zone. That housing overlay zone is something that they want to look at, because that will be allowed to be implemented on specific sites throughout the town, that the Planning Commission will go through a process to vet each one of those potential available sites, as well as the regulations that would potentially go into an overlay zone. In other words, like, what is the most appropriate density? What are the situations on the available sites, and what is the access and the roads? What are the possibility for septic and water and things like that? The Planning Commission wants to do it in a very comprehensive way so that they bring the best choices to the citizens of the town. Also, a housing overlay zone, obviously, once they go through that process and identify potential sites where a housing overlay zone could go, that is going to end up being a zoning code amendment that will have to be forwarded to you, but it will be forwarded to you with a very comprehensive package of understanding of the review that they went through, why they vetted the density. Your question right there that was asked about, what is the percentage of units that would include? That's what they want to do. They want to review that in a detailed, comprehensive planning way so that they can bring you the best package for you to consider, and then ultimately, hopefully, adopt into the zoning regulations. The PDD is also another potential process for doing that, just as Attorney McTaggart has laid out. That's another potential process. There's no doubt about that. The question is, though, has that process been well thought out, just like what the Planning Commission is going to do related to the housing overlay zone and those particular sites? We know, even though we're supposed to be looking at this application in a generic way, that this is supposed to be a PDD that could be anywhere, we know that the applicant does in fact have a site and has been basing their development of their proposal based on that known particular site. But you, as a commission, you need to look beyond just that individual site. You need to look at all the possible sites that this PDD could be overlaid and what the implications would be. Now, Attorney McTaggart has laid out a process that, yes, an individual site plan would have to come forward to you, but and also be considered by the Planning Commission. But is that really the proper way to do it. In other words, do you really want to, would you rather comprehensively in advance of making an amendment to the PDD or otherwhere in the zoning code, would you rather develop a good set of guidelines up front so that you are comfortable with them, or do you want to be approving or denying applications as they come in? And is that more of a haphazard approach, or is it more of a comprehensive approach? Those are things that you have to decide. But the Planning Commission has laid out a recommendation that they feel that they would much rather it be done in a comprehensive way. And I think, you know, related to the POCD, the Planning Commission has to make sure that it meets all the recommendations of the current POCD. Attorney McTaggart laid out a very good plan of how it in fact does meet the POCD, but it only takes one thing in the POCD that it would be contrary to, and the Planning Commission has to find it not contrary to the POCD. Because you can't just say, well, that one's not important or something like that. They have to find it, unfortunately, it has to be 100% in compliance with the current POCD. And so that puts the Planning Commission in kind of an odd position, because even if there's 5 things that it's really in compliant with and 1 or 2 that's not, then they have to make that recommendation. The Planning Commission is also, as you know, currently updating the POCD. It's getting very close to a final adoption, and that's also odd that we're making this recommendation potentially on this PDD amendment at a point when the current POCD is almost 10 years old, and within a couple months from now, there's going to be a new POCD on the table that could give this PDD text amendment some new light or a fresh viewpoint. You know, and if you look at the letter that the Planning Commission forwarded you from the chairman that was sent on September 14th, if you read the number 4 reason, obviously the commission laid out 4 specific things, but if you look at the 4th one specifically, it says the Planning Commission suggests that the Zoning Commission carefully consider in its review of the proposed amendment to Section 12 of the zoning regulation, the location where multifamily housing may be located relative to sound community planning principles, overall density, and the adequacy of public facilities, including sewage disposal and water supply facilities, and availability of pedestrian and vehicular circulation systems to support multifamily development. It should be noted that in Chapter 14, Policy G of the 2012 POCD, existing sanitary sewers should not be extended beyond the existing service areas or capacity in the treatment facility to be increased. So that's something that, again, that would take a comprehensive review by this commission to make sure that all the eligible sites would potentially be adequate. If not, the other approach would be to do it on a case-by-case when the applications come forward, but that also could lead to haphazard thinking, is what the Planning Commission was thinking. In our review specifically for the Zoning Commission, in our report, you know, I also want to point out on page 3, the last paragraph, I just want to remind you again of what we said here, because it's also focused on it being a comprehensive viewpoint, that you need to take and consider other sites that would possibly be eligible for this. And that is, the threshold question before the commission is whether the proposed amendment by Section 12 by the North Point Ridge is the appropriate way for the town to advance the needs to address affordable housing development, consistent with the recommendations of the Affordable Housing Plan and recently adopted amendments to Section 8.2 of the General Statutes. As an alternative to incorporating the specific recommendations applicable to multifamily housing with an affordable component in Section 12, the Commission may wish to establish a separate section in the zoning regulations specifically for affordable housing that addresses location, density, adequacy of infrastructure, including roads, sidewalks, sewage disposal, water supply, and other important factors related to site development. The Commission could identify specific locations In other words, through a housing opportunity zone, for example, for incorporating such housing within existing zones where such housing would be deemed to be compatible with other uses. By considering such alternatives, the commission would leave the planned development zoning mechanism in place to continue to address unusual land uses and development circumstances, which is one of the primary goals of the PDD. If the commission determines that the proposed amendment to Section 12 is not the appropriate means to address multifamily housing with an affordable component, there may not be a need to address the specific technical amendment proposed by the applicant either. So again, it's really important for everybody to understand that all of us are supportive of affordable housing, but it's just the approach that is wanting to be taken at a comprehensive level that's being suggested, both as my hat as a planning consultant to the zoning commission, and then also the representative representing the point of view of the planning commission. I think another solution would be very easily that we could work with the applicant that is in front of you tonight for this PDD, and they could help us and the planning commission craft an overlay zone that would have an affordable component to it. And we could potentially utilize some of the information that they've supplied in the PDD to go into the affordable, the housing overlay zone. The housing overlay zone would look at, again, specific sites and not be up to random unknown sites that have not necessarily been identified. It is true that the PDD would put the process more in the court of the private developer, which is obviously a good approach. But I think the town and the planning commission are really saying that the town would really like to take a forward view of this and identify sites that they feel are appropriate and that have been vetted by the community as well as in a well-thought-out process. And it's possible that the site that the applicant has could potentially have that overlay put in place above it, but it would not necessarily have to be on another site that might not be appropriate, that could be eligible for PDD. So I think those are some of the opening points that I wanted to make. I'm hopeful that we can have a continued conversation and you can ask more questions, but I wanted to just make sure that I pointed that out and that acknowledge that we agree with Attorney McTaggart that affordable housing is desired, and that it, you as the zoning commission do have the rights by the state statutes to consider things like multifamily housing. I don't think there's any question on all that, but we're just mainly talking about, is it the right approach? And are you taking into consideration all the potential sites that could be impacted by this new regulation if it was adopted?
Can I ask a question?
Sure.
And I apologize up front for my ignorance. However, help me understand, what do you mean by a overlay zone? What are you talking about?
Okay, so an overlay zone, how it would work would be, and there's all kind of different overlay zones. It's a common planning zoning term. And basically, an overlay zone allows for the underlying zoning to stay in place, but it basically puts an overlay over it and says that this is an option that is also allowed in that particular zone. It's very commonly used, like, say, for instance, in like a downtown area where that might be zoned commercial. And then you say, well, in this particular part of downtown, we want to have a housing overlay, or, in a downtown, it could be something else. It could be like an arts and entertainment district. And so therefore, rather than having to go in and change the statutes to change that specific zoning district, which could have implications in other areas where that zone might be, it allows for you to just have that an overlay in that particular area.
And so that overlay is specific to that area?
Yes, it would be very clearly defined, and they always are on any zoning map. The zoning map would actually have the overlay identified, and the way that the Planning Commission has been thinking about it, and I know that the Chairman Tirdo could also talk about that, even though they haven't started looking at the overlay in more detail yet. But individual sites throughout the town would be identified as eligible, and then those sites would go through a vetting process that would include the community, determine the best sites where the existing zoning could stay in place, but then the overlay could be put on top with the understanding of what those regulations would be, including density, access, infrastructure, and things like that. And so, you know, and therefore, if somebody would come along and say that zone was a residential zone right now, but it was a lower density, that could be freely developed as that zoning district. But if somebody came along and said, but this one has a housing overlay, and I think I might want to use those regulations in addition to the underlying. I think in the Main Street area too, I think the overlay would be very beneficial where it's determined it could be used, because right now that's all commercial and it doesn't allow any residential, but the overlay would allow residential to be located there where it might be deemed appropriate.
So overlays are unique to each location.
That's correct. I think in this particular case, the housing overlay would probably, it would be unique to locations, but the overlay itself would probably have similar guidelines and regulations. And that's something that the Planning Commission will have to determine, is whether they are, all the sites that get identified throughout the town have the same regulations than the overlay, or whether they would make different types of, you know, maybe they would have 3 or 4 different housing overlays, one that's more higher density, maybe one that's lower density, maybe one that allows for slightly higher affordable units or something like that.
Why can't our present PDD regulation, whether modified as proposed, or modified differently, do the same thing?
Well, that's what I mean, I said, the PDD is another mechanism that could be used, but the only thing is that right now, you'd have to, in order to feel, I would think in order to feel comfortable in approving it, you would have to do an additional study to determine all the sites in the town that could potentially have the PDD put on top of them, so that you don't get haphazard applications coming into you with it that you end up having to turn down or something like that.
Are you aware whether Southbury now has any multifamily properties being developed that isn't subject to affordable housing?
Well, there is a couple. I know that the chairman from the Planning Commission could probably answer some of the ones that recently got adopted by the Planning Commission. I mean, there is a couple that have come on board recently that have an affordable housing component, that have affordable component. I think like Grace Meadows is one. Do you know a couple of the others, or do you want to speak on that?
Richard Theodore, Planning Commission Chairman. Kevin Bennett did 2 developments, one last year over on Route 67, and one on Old Waterbury Road. He's in the process of finishing as we speak. And they're both affordable housing components. I don't know to what percentage, but they're both were applied that way and both approved that way. So they are.
And so my question would be, what is the overlay in existence or that was considered that allowed those to go through?
Yeah, there's currently not an overlay,
Right.
so those were adopted based on the zoning.
Just the
underlying.
zoning regulation for that area, correct?
They were 830G.
So if we
No,
are.
actually,
they weren't.
they weren't. They originally applied for it, but we approved it as a regular
Oh,
development.
okay, so it was applied for one, but,
Yes.
yeah, okay.
Yeah, they weren't 830G.
Wait, I'm sorry, I didn't get the benefit of the question and the answer.
So they were not housing overlay zones. They were regular approved for the zone.
But they do have an
Affordable housing component, correct.
So what is the distinction between that and the approach that is now being recommended?
Well, I think that that approach that approved those projects could still continue. The hope with the overlay by the Planning Commission is that there ends up being more focus on, and once you create the overlay and it makes it more clear where affordable housing is desired or additional housing, that it basically puts a focus on that property that, hey, this one's available, let's get it developed with some multifamily housing or affordable. The projects that were developed by that, again, they just were brought to the town by a developer based on their thinking rather than the town making the suggestion on where a developer could potentially go. So,
But I have one last question, and then
No, go ahead.
I won't ask, because one of the words you just used in your response is the word desired. And what I heard also is, and a part of what your statement was, that a part of component of this overlay was the community deciding whether is an approach to, ensure that if there is a part of the community that says, not in my part of the community, that is really the, the incentive for having this overlay provision to, as you said, having community involvement. So if people are, concerned that there are affordable housing coming too close to where they live, that this is designed to create that mechanism. And I'm just trying to understand what the overlay versus the fact that there are buildings right now currently, in existence that did not have to go through this vetting process. What does that really indicate?
Want me to answer that, Robert, or you want to?
Well, I'll just make a quick statement, though, at first, is that, I mean, I think some of the issues that you're talking about, we don't know how those are gonna come up, because the sites haven't necessarily been identified. And I do feel that, that's why the commission wants to very carefully look at availability sites, and then, have a community discussion to figure out, because it's not just whether the neighbors agree or disagree. We gotta look at it based on, whether it's, what size it is, what density could go on it, what the availability is for septic systems on it, and how many units that could handle. So it needs to be looked at in a comprehensive approach. It is possible that an individual resident or community could come out against a particular site, and the planning commission will have to decide whether there's enough other benefits on that site to override that. The same thing could happen, though, on the PDD applications, because if a PDD if this got approved and a PDD application came up on a site, there's a likelihood that residents could potentially come out in opposition to it. Obviously, with a 830G application, there's not that availability or opportunity, I should say, for anybody, because it just gets forced upon the community.
Right. Which really is a concern. I'm not sure why that's not a more prevailing concern, that Southbury controls its own destiny than
Right.
the 830G, which, like you said, there's no control. But again, we're doing this anyway, so I can't, and maybe you can correct me if I'm wrong, I can't imagine this committee or planning saying to any other types of builders, and single family home or whatever, is that we need to know where you plan to put this before you can even address, this process of building whatever structure it is. So that's what it's just not making sense to me, that first the planning committee needs to figure out what areas these housing needs to be, and that needs to be a deliberate plan before affordable housing can come into existence as a part of what, again, must be done in Southbury and many other communities. But there needs to be this forethought of these overlays and places where they can be allowed to be. It seems to me, in that sort of reasoning, that what we are saying, in fact, is that there are certain places we definitely don't want these to be, and we need to ferret that out before we even allow this to go forward. And I'll end that there. That's my last piece of
Yeah, I mean, I think the
contribution.
planning commission would welcome, yeah, the
That's what
planning,
it sounds like
yeah.
to me, so I just want to be very candid. That's what I'm hearing.
I mean, I think the planning commission wants to make sure that everybody is involved in the process, so that it could be determined.
I heard
and-
what you said, and I'm not saying that's not what the basis of what you presented is. I'm just telling you how it sounds to me, and why I'm asking the, probing questions. I'm asking some clarifying questions.
Sure.
And I just,
One other quick real point is that, remember that the housing overlay would be something that the zoning commission would approve, and the regulations, as well as maybe the initial locations. But it will be a zone that's in the book, so if somebody comes around 5 years or 10 years or 2 years later and wants to have it considered on another site, that will be there, that will be available. Just like, so if a developer has a site that was not considered in the first round of discussion, They could go, they could go and go through overlay, come to the zoning commission and request the housing overlay to be placed on their property. So it would be very similar to the PDD process. It's just that the town would have been in control of developing the regulations from the beginning, rather than a developer making the recommendations of what the town's regulations should be.
All right, so I like one last thing. I will say this. So, we have Heritage Village, and we know, Heritage Village exists for a certain community. Of course, that's how approved, of the age restrictions, rather. I mean, my teenager couldn't
Right.
purchase a property there. But as we've been talking about this, we're not looking to have concentrated areas for affordable housing, like a Heritage Village type situation, where everybody knows, everybody that lives in this part of town is in affordable housing. And I think that would be disruptive to the character of Southbury, to have specific apportioned parts of the town where everybody knows these people who live here are in affordable housing. And so again, the overlay is of concern to me, that idea that we need to go out and figure out some parts of towns where these properties are allowed, and then stick them there, and these are the only places. I think it should be less, or it should be innocuous. It shouldn't be something that is stigmatized or stuck in areas that create more, as far as I'm concerned, potential harm to, whomever might be concerned about this. I think it should not be stigmatized, and that's.
Yeah.
It feels like to me, so I'm just, again, promise, this is the last thing I'm saying. But I just want to be very clear that that's what I heard in the language of desirable and communities, having a say and deciding if they want it in these locations, et cetera. And I do think there's a component of when you speak about affordable housing, but it tends to be, and I mean, I think that is the, sort of elephant in the room, that it tends to be thought of in a way that is, all these undesirables in a community that we don't want, and we want to make sure that it isn't done in a way that destroys the structure or the character of, the town. And I, like anybody in this room, want to preserve Southbury as it is and has been. So little pockets here and there, I think, would be of concern to me. So I just
Well,
wanted to put that out there.
Yeah, I mean, I really feel like your viewpoint is exactly the same as the planning commission viewpoint. I think, it's altruistic perspective that the planning commission has on wanting to get affordable housing. And I think during the process for the affordable housing plan, I don't know necessarily how involved you were, but, we went extensively out of the, as we could, to try to explain that affordable housing is a lot different than what a lot of people think. The community survey that happened during the affordable housing plan, there was a full range of comments that came in, and some fed into what you were talking about, but there were many others that people understood the needs for affordable housing. It comes with, and this is explained very clearly in the affordable housing plan. And in some cases, we were trying to turn the conversation around to housing affordability rather than affordable housing, because we're talking about, seniors that have 5-bedroom houses, but they need to downsize to something else, and they might not be able to get something that's in age-restricted community like Heritage Village. Another type of housing that was talked about was, smaller type of units, because the overwhelming, if you take Heritage Village out of the equation, which you can see in some of the tables in the affordable housing plan, if you take Heritage Village out, the town is almost predominantly single family, so there's not that housing variety. So one of the other goals or strategies of the affordable housing plan is actually to encourage and promote more ADUs, smaller units that single-family homeowners can put on their property, because there's this need for homes for residents of the community now that have children that might be graduating college that want to come back and they can't. There's housing needs for firemen and policemen that are not able to find like smaller units and things like that. So, right now, the initial need for affordable housing for Southbury is targeting those individuals, because that's where that need is. They're residents that are in the town now, because there's, over 20%, almost 30% of residents now, as Attorney McTaggart mentioned, would qualify for being 80% or AMI, less than 80% AMI, area mean income. And so therefore, the need for the initial need for affordable housing is for residents that are already living within the community. And so I think the hope is that these locations that could be identified for an overlay or a PDD or something like that would be being targeted towards existing residents. And that the product should be being aligned with those needs.
Well, I agree with that sentiment, but I just see the sort of 5-year, like, I just don't understand. It doesn't, saying 5 years down the road, sort of the plan, proposition, and saying we see the need now and this is what we're trying to do, just doesn't, the two don't seem to align. So again, I guess I have a lot of questions, but I'm gonna just let somebody else ask or comment as needed.
I guess, what I'm not clear on is how do you, explain to me that the PDD process doesn't meet that need? If someone comes in and puts in a request for a PDD, they're gonna say, I wanna do this here. They tell you exactly where they wanna be and what it is they wanna do. And so when we look at a PDD, that's what we're looking at. This overlay thing, I kind of like you, Wendy, it's like, so what? You've already picked out spots and then people can come in? I'm confused.
Well, initially.
Just to add to that, the PDD process here in town has worked very well. We have very good PDD developments, over 20 of them. And we rely on the developer to come in and put his best foot forward and give us a quality development, which is what we're hoping to get with this change, as opposed to regulating areas in town for overlay districts. Let the private developer, the private industry put its best foot forward and give us the quality project that they know they can make money on. Again, we have yet to come up with a PDD that doesn't look good, or doesn't fit into the town. It's
Yeah.
not controlled by us.
Yeah, I mean, there's no doubt about that. It's just, again, the overlay zone idea that the planning commission, again, this is their idea, and Chairman Tierdo can also give you more information from their perspective on that. It's not supposed to only identify specific sites. Their goal is to maybe identify some initial sites. The most important thing is that it would be another tool to be within the zoning code that would more clearly identify for housing-specific needs, and also to help answer the affordable housing question. And if you feel that all of the possible questions within the PDD are being answered, well, then you have your answer.
Is there a possibility to accommodate both?
That's what you have to decide.
I mean, right now, we're seeing the opportunity to, a developer wants to come in and give us, again, based upon past experience, and Mark has done a lot of work.
Sure.
Mike has done a lot of work with us, and his representation of clients for PDDs in town, and they've all been quality projects. I assume it's gonna be the same type of quality project, because I know Mark.
Of course.
So here we have an opportunity where he's knocking at the door right now.
trying to get this approved right now.
Well, and I think to add to that, Gary, what's the benefit? In other words, should we be willing to wait because what he's talking about is so much better? To me, that's part, and I'm not saying it is, I'm just saying, if it's not, then what's our point? We can go to the PDD and accomplish what we want through the process that we've always used, which is to have a developer come in and sell us on a particular project in a particular location, as opposed to someone's found there's locations out there and we're gonna plug in a project.
And the other thing about the location is that if it's found, and then the town, the planning committee now has to do the work to vet it, why are we expending resources, public
From our town.
resources, when the builder does that through the PDD process and expend their resources
Right.
and
Before they even come to us.
before they even come to us? And
Exactly.
those things are, as far as I'm concerned, more cost effective. We're not, the town's funds aren't being used to vet
Right,
projects.
right.
I just don't see that as the best use of our resources.
I would agree, I would agree. I'll be quiet. You and I talk too much, Wendy.
No, it's okay.
Would you like to speak, Richard?
Richard Taylor, Chairman of the Planning Commission. I just want to add a little bit onto what Mr. Collins had said. Basically, the Planning Commission spent, the beginning of the year working on the affordable housing plan. I mean, countless hours, meetings weekly, 2, 3, 4 hours to get it done by the June deadline that was required by the state, and we got it done. And it was obviously the first plan that the town ever had done, completed. And at that point, we decided to form an affordable housing plan, which is a subcommittee of the Planning Commission, which Mark is on it as part of our team, and some of them are in the audience tonight are on that as well. And to Mr. Collins' point about the HOZ, on the Housing Overlay Zone, we wanted to form a subcommittee to do that, to do a study on that, to find the right spots in the town. So we have a list of town properties that are available, and there's private properties as well, which can be used for affordable housing if developers wanted to buy that from a private citizen. And to find out which would be appropriate for the town to have any type of development, whether it was affordable housing or not. And through this whole process, the Planning Commission was really looking at the whole overall presentation that came from Attorney McTaggart, and we feel as though even from the last meeting from last month, the applicant and Attorney McTaggart made the Planning Commission look like we weren't on the side of affordable housing, which is wrong. The Planning Commission is very much behind affordable housing, 100%. And we spent countless hours getting it done in the POCD, and they made us look like we were not. And that's really sad for them to do that. And I just had to make sure you understand that that's where we're coming from. So the subcommittee was formed to really look at the projects that come into the town. And right now, Attorney McTaggart's running 2 applications at one time here. It's the way we see it. There's a PDD application for the change for the PDT language, and she's at the same time running her application on the side, which isn't even registered with the town yet, from the developer. He talked about his economics, which we feel is inappropriate. It's not even on the table or document with the town at the moment. And I understand what Chairman Giroux is saying about the representation and the references and the reputation of the people that are doing this. I understand that. But there's one thing on the table at the moment, the PD change of the language, not the application that the developers are pushing. And we felt that was not appropriate at all. The commission actually looked at this application very closely at many of our meetings and decided that there were 3 things that the consultants had mentioned as well. We asked them to just pull their application until the POCD for 2022 was done, which will be December, January timeframe. At that point, they could come back with their application, and the ink wasn't even dry on the affordable housing plan when they put their application in. It wasn't even dry yet. And we're trying to figure out where we were headed with the HOZ, which is very important to the town. Because we can decide, based on the town's own property, there's a list of multiple acres that can be utilized by builders if they came to the town and said, we want to buy land to develop a property for the town for affordable housing, and the town could sell it to them. Or they can go to a private person to buy land. It didn't matter how it worked. So that's what we're looking to do. And this subcommittee is going to look at these applications and decide, does it make sense for the town, as you mentioned earlier? Do we want this project there? Or, yes, we really want it here. And the HOZ application really looks at, can folks get to the library transportation to get to the grocery stores, things like that, where it's placed, right, to handle those things for people. If they're way out in the suburbs or way out on the town edge, there's no transportation to get to these areas for these folks. And no one knows who is actually an applicant of affordable housing within a project. No one knows that. They just know that because we know that as the planning commission, because the project came in that way. It's not earmarked, you are living here because you have affordable housing. No one knows that. So that answers your question from earlier. It's not really designated that each individual is affordable housing, whoever the person is. The development may be based on one or two applicants that are in there based on the amount of apartments that are in the facility. So the commission looked at the overall application and felt that we needed time to study the HOZ lane, overlay like the SLR is recommended, and have a subcommittee of the planning commission, the affordable housing team, look at all the applications and decide what really made sense for the town. They're not for or against anything. They're trying to make sure that, is it right for this spot? Does it make sense for the town? Is it good for the townspeople? Is it nice for the people who want to live there? And can they get around if they're unable to or not able to afford to have a car or transportation? Because the town has no sewers in those areas that the applicant's talking about. And Attorney McTaggart had a lot of density information that she kept pushing to you from other towns of the high density. But they all had sewers. We don't have that in Southbury, in this area where they're looking at. Only in the center of town, where there's not a lot of area. So these are areas that the planning commission were concerned about, as well as parking as well. 100 units, 150 cars or more, we're very concerned about these areas of where they're gonna be put. So that's why the commission looked at a negative referral back to you folks, which in the past, the zoning commission has never really gone against the planning commission when we give it a negative or positive referral. You guys have always gone along with what we've decided. We look at things in a broad aspect and give our heart to it as a decision for the town. And we felt in this case that we really needed the time, we had to give a negative referral back, because we feel that we need them to pull the application, wait for the POC to be finished, and wait for the HOZ study to be completed by the affordable housing team. And that's where we're at with it.
I wanted to mention one other quick clarification, just real quickly, is the housing overlay zone would not necessarily only have to be affordable housing.
Right.
It could encourage multi-rate, market rate housing.
That's right.
So I wanted to clarify that it's not necessarily only supposed to be affordable housing, that it would be market rate housing, because the town could again benefit from just having a variety of units so that there's more choices, because that's one of the biggest goal of the affordable housing
Right.
plan, at least for this round. But that the overlay zone, the housing component would then also have embedded in it affordable component
Right.
as well. So it would encourage market rate housing as well.
And we want to make sure that if an application comes in, and the commission's not for or against it, but 10%, 20%, whatever number is, does it move the needle for the town, right? We have to get to a certain goal, and does that help the town? That's what's important to the commission when we look at the applications as well. And the HOZ is a very important portion of that, and the subcommittee will, look at that for the affordable housing, and then report back to the planning commission, and then we will report back to you folks if it's a referral from zoning. So it's a very important process that I think we all need to take to heart, is when we look at the overall, changes to the PDT. No one's against it. We understand the new laws have changed, but we want to make sure that we just take our time and do the right thing for the town. I don't see the rush, and neither did the commission.
So are you saying that because in the past, planning, zoning, agreed with planning, that is what your expectation?
No, not at all, not at all. No, it's just we've always heard back from zoning, or the zoning's approved it based on what they thought was right, even if we had a positive or negative referral, and that's how it works. That's fine, we understand that, but it's just.
I think that's the process we're in right now. We have.
Correct.
There hasn't, right, so.
Right.
The thing is, to be quite honest, I just didn't realize there was some hostility baked into all of this until you just stated.
We don't
that.
see hostility, we just see that there's a time being rushed on something that the zoning commission is going through your regulation changes, right? You're doing your refresh or your revamp, whatever that you want to call it. And they're not even finished yet with that. And the HOZ study's not even completed yet. The housing subcommittee was just formed. The ink wasn't even dry on the affordable housing plan when the applicant came in with an application. And from the beginning, it's not just the PDD text change, it's we have a development. Otherwise, the developer wouldn't have talked about his economics last month at the meeting. It's just inappropriate. It wasn't even on the table. It's two separate things. The text amendment's one thing, the application isn't even in yet for what they're talking about. It shouldn't even have been mentioned. So there's no hostility, it's just the commission's confused. And we gave our recommendation on our negative referral back to the commission as to what we thought would be best. Pull the application, wait for the POC to be finished, wait for the HOZ study to be completed, wait for the Affordable Housing Committee to get the study completed and understand what's going on in town and what are the best properties available. That's all we thought.
I think, you know, just going back to the PDD process, which has worked in Southbury.
Oh, of course it has. I've been at commission 12 years. I know that for a fact. You're right.
Right, yes, this is my first time on the zoning
Yeah.
committee. I've been in Southbury for 17 years.
Sure.
So, you know, very new to the process.
Sure.
But I do just don't understand the distinction
Mhm.
between, you know, sort of this waiting and sort of
Mhm.
you know, there's an urgency, as you mentioned, and there's an understanding and there's support, but there is an energy that is being put on the waiting part of it that I'm just not really understanding, especially as you indicated, there were two developments, one still underway, that does have the affordable housing component, and there wasn't an overlay, there wasn't you know, the ink wasn't even down.
It was 3 weeks. It was 3 weeks.
So we recommended
No,
6.
I'm talking about
I
the
know.
ones before the ink was even put.
Right.
So I'm saying, there was no ink to be discussed, right? So I'm just not sure what the underlying issue is. It seems to me there is something else that isn't being discussed, and I'm just being very candid, because there's a lot of animation here.
We'd like to know it as well then, because we're confused as well. We're trying to just do the right thing for the town and do what's in the town's best interest.
And
And the Affordable Housing Plan, like, as Robert had mentioned, had recommended 6 ideas for affordable housing that the commission decided were best.
For the
And
next 5 years.
for the next 5 years.
About the state, you know, builder coming in on the state side and just, you know, bypassing us.
No, we've had 830G come in before. It's happened. I mean, to be honest with you, 20% from the
You
builder.
get more affordable
We'll get
housing units that
30%
way.
affordable housing. That
you
moves
got-
the needle for the town.
We don't have as much say in it. I mean, are you?
I
concerned
understand,
about that?
sure we are, but if a builder wants to come in and do 30% for the town, that's in the town's best interest for affordable housing versus 20.
And it,
But there's no overlay to tell them.
No, I understand that. I understand that, but that's the risk we take. All towns take that risk right now. I mean, there's a ton of towns, and if you read the paper every day, there's Fairfield, and there's many towns that are having this trouble right now with 830G, and it's all over the state right now, so we clearly understand that. 30,
My only question about that is, isn't it in our best interest to quickly control our destiny?
that's the other side of the spectrum, you're correct. Yep, but sometimes that, moving fast like that may not be best for not only just this one project, but what comes in the future.
and there could still be an 830G that comes in that just comes in, and they don't care about the fact that you amended your code for
That's right.
a PDD or a housing overlay. It could still come in.
Right.
And, you know, again, the thing that the planning commission, I think, is wanting to make sure that it's very clear, and you both also mentioned that because you talked specifically about Mark Lancourt and his product. And that's unfortunate because that, yes, he has done, and his team has done wonderful projects and all that, but you have to look at this as if you didn't know about that application. You have to look at this because what happens if you didn't know the potential developer? Would you have a different opinion about it because of not knowing that? And, you know, I mean, I think that's something, and that's all that the planning commission is asking.
I
Is
agree.
just try to make sure that you view this from a clear lens, rather than it being kind of somewhat framed in by the applicant and knowing what they could bring to you, because another applicant may not do that. And then what will your opinion be at that point?
What I do know from past experience in the past PDDs that we've approved, we've had control over and dictated a lot of the outcomes of those PDDs
Mm-hmm.
Sure.
to our better,
Oh, sure.
best interest.
And they weren't necessarily coming through local residents.
Right.
You know, it wasn't because we knew the person coming in and putting in a proposal, but rather we listened carefully and then made decisions beyond that.
And-
One of the advantages
Yep.
of being in a small town is that you do know the people.
Right.
And you know, and you appreciate and understand, you know, if your reputation isn't good, believe me, that gets out a lot faster.
Absolutely, and the commission, and especially planning, has no disrespect to,
No, absolutely.
we like Mark Lenkor very much.
Well,
and
but
we're
I
very-
don't think that we
and-
should
and the rest
base
of the
it on
team. It's just-
personalities.
right.
I think that what we have to base it on is our ability as a commission to take an objective look at what comes before us and whether or not it's appropriate and realistic.
And the same as the
I
planning
don't
commission
think
as
that
well.
those, you know, names
Yep.
of who they are, because we've had people come from other places and put programs in that
Yes,
that we put a lot of time and effort into, and as Gary said, we had the ability to control a lot of the outcome of what it was gonna look like to our town's best interest,
right, and that's what the planning commission's trying to do as well,
right?
no doubt about it.
So I think there still may be an avenue to allow both means to exist.
Just a matter of coming to some type of, not agreement, but something that works for everybody.
I think from the point that, again, unfortunately, as you mentioned, knowing that the process of changing the PDD and having a potential developer at the same time, sort of mixes everything up. And, but I think right now, we know for a fact that, okay, there is some potential
Mhm.
to develop again. And, we have an opportunity to do something for the benefit of Southbury now. And I don't know how long it's gonna take for this HOZ to be developed and be approved. Whereas, I'm not saying we're gonna approve anything tonight, but the process could work a lot quicker. Maybe from the PDD point of view, but I think we should also pursue the HOZ. And, we can always change the PDD later if we think the HOC is a better product. I think right now, something's before us that potentially could be before us. Again, I don't wanna say something's before us, because it's not. All that's before us right now, as you said, is the language of the zoning regulation change to allow, multifamily, housing to be developed in certain areas of town under the PDD process. I don't know, food for thought. Again, I'm gonna recommend that we hold the public hearing open until next month.
Okay.
That's my recommendation. And, between now and next month, I wanna hold another special work session with everybody.
Can we have like 15 minutes to respond to what we've just heard?
Yes, you can. Oh, absolutely, yeah.
No, we're good, thank you. Do you have a question? I'm sorry. Okay.
No, thank you.
Okay.
It's very,
Okay.
clarifying.
I just like to respond while it's fresh in our minds, if you don't mind. It's a public hearing. I'll try, okay. Okay, let's see what I can do. Actually, this is pretty early. Yeah. Okay, first of all, I was shocked to hear that there was any hostility. I think we've always been respectful. We did respectfully disagree, and I can't help but say that I did disagree, but I don't think we ever were respectful, and we did understand how much work it is and the deadlines for the affordable housing. We get that. But we also had, running at the same time, we had all of the statutes and everything happening that was also telling us what we needed to do there. What we did was, I think, exactly what your chairman has been saying, is we weren't saying throw out your objectives in the affordable housing plan and don't do those. We were saying that this could run parallel and provide an opportunity. And and I still believe that can happen. And when we looked at the objectives, because we were asked to look at those and see how we complied with the objectives of the Affordable Housing Plan, and you all have a letter, and if you will read it, it was dated July 7th, it was revised to September 1st, and it's been provided to you, and I'm just going to take hopefully less than 5 minutes. But objective 1 was procedural, to establish a committee that they were going to put together a plan as a starting point and guideline for future zoning regulations. It is true that zoning regulations are written by this board, this committee, this commission. The Plan of Conservation and Development is a vision for the town and what the vision is for the town. And the study was going to talk about the future use of the Southbury Training School. We looked at the website for the Southbury Training School. It's been all over the park for so many years, it's very hard to know what's going to happen with that and how realistic that was going to be. They were looking at, could there be congregate arrangements? I think I told you that I had worked with the Pierce Hollow Group, very advocated very strongly. This commission did some changes to the zoning regs to allow the senior housing. We can't get it done, we couldn't get it financed, we couldn't make it happen. So the fact that you've got a place in town that's got, on a map says you can do it there, doesn't mean you can do it there, okay? When the developer comes in and tests it and figures out what the site supports, then you do have information that you can work with. Objective 2 was to explore options for ADU units, okay? Well, these aren't ADU units, okay? And there's a whole section about that. Objective 3 was to explore adaptive reuse of existing vacant buildings, and I did feel like that kind of thing makes a lot of sense in cities and towns that have a lot of vacant commercial buildings and places they could do it. I live here, I just didn't see a lot of that here. So I didn't know how that was gonna work out. It suggests that, it did suggest the bonuses for deed restricted units and encouragement of historic preservation. So we felt that objective we were looking at and did comply with. Objective 4 was to explore overlay zones, which you've just heard about. And I would say to you that if the overlay zone does whatever areas they decide that people can drop those overlay zones down onto their property and then do whatever it says in that overlay zone, which is what they do. What I think I heard is that if you wanted to be in that zone and you're not included, then you would come in and do an application into this commission to be included in the overlay zone. I don't see how that's any different than coming in with a PDD and saying, I have a good location for something here and design merit, and I'd like to convince you or sell you that this is a good idea for Southbury. So the overlay zones, and again, I don't think they're mutually exclusive. We didn't say to them that they were. Objective 5 was to promote first-time home buyer education for financing. Okay, we're looking at rental units here, 1 to 2 bedroom units. And objective 6 was to further explore encouragement of cluster subdivisions, which we are not. So when we looked at these objectives, it's not that there's anything wrong with the objectives, they just didn't jive with what we think we should be doing as an alternative. And I think that for sure, that the PDD process, I just know from experience that this commission is not easy on applicants that come in with PDDs, that you make them provide the design merit and the special kind of development that the town deserves. And so it wasn't that we thought they did a lousy job with their document or anything like that. We just looked at it and said we didn't think these objectives had any, they didn't have any much bearing. So we're gonna wait around for the committee to carry out objectives that don't look like they're headed in a direction that will do the kind of affordable housing that we're looking at. And I will say to you, as counsel to this town, I've been counsel to this town over some years, but to other towns, that there are 8-30G projects that you really will not be a benefit for this town, and you're really going to, and they can happen anyway, I understand that. But if you have a 20% requirement and somebody can come in and do this, and do it consistent with guidelines, and we put the guidelines in, they aren't they're not sitting out, and those guidelines are like the underlying zone but stricter. So those guidelines weren't just created out of whole cloth somewhere. We looked at the R60 zone, we figured out the coverage ratios, we looked at the number of stories, we did those kind of things. So it does do a lot of what the overlay zone would indeed do, but in a different mechanism. So that's it. I think that's 5 minutes. Might be 10. So you need an extension from us to, what had been suggested is that, two things, that this commission might want to have a work session, but you're in the middle of a public hearing process, so that has to be a public work session. We can sit and be as quiet as we can stand in one of those sessions, I suppose, and, but we have a right to observe it and be there, and it has to be noticed. And then to get out to the next meeting, which is the November 11th is Veterans Day.
Mind if I join you just for a second on this part?
Yeah,
Just so-
sure, no problem.
I have notes on it.
Okay, so how many days do we need?
To get to the 9th, we'd have to extend it 27 days.
And we have 30,
You have 32 days left.
we used a bunch of days to open this, and so we've used up some of the 65 days that we're entitled to extend. So we can extend out
Yep.
to that November meeting, and then I think we would be willing, if you were to schedule a meeting in between, that was a time for all of you to look at all the information, talk among yourselves, maybe not deliberate, but just, because deliberation should happen after the public hearing is finished, and you have all the information.
Right, and I would just add a word of caution, because there's a line between deliberation and discussion, right? So during until you close the public hearing, you shouldn't be saying things like, I like this application because, I don't like it because, what do you think? You should be talking about the points and the questions, the issues being raised. So I know it still will be hard, because it's a natural, I don't like this, I can't support it. That's deliberation, so.
It's usually, I would never approve that.
Right, so it really, focus on the questions that you have about what was said, what was done, what's written, what's submitted, and that you have for the applicant and for SLR. And if you have any questions for legal counsel, if you could let me know before one of those meetings, that would be great, if there's something you want addressed.
The only other thing that, so we can provide you with a written extension, which
Okay.
I can send it
Just send
to,
an email to Bonnie.
okay, I can do that, so we'll do that, and we're looking for, give me the date again, I want to get it down.
The next regular meeting I have on my notes is 11/9.
And then the only other thing I was going to say is that I guess since the next session might be a work session, I probably won't be doing a lot of talking. So I disagree that the consistency with the plan of conservation development means that every little thing in the plan of conservation development is complied with a proposed zoning regulation. Consistency, I do not believe that's true. If there's some case law that says that, I've never seen it. It does mean that sometimes planning commissions say it met most of these requirements, and the word is they approve it, disapprove it, talk about modifications that they'd like to see, all right? So it doesn't mean that it's not there. They're allowed to report on anything else that they want to say. The planning commission report looks at consistency is the word, and it also gets an opportunity to say whatever they want to say. I'm fine with the fact that they've made the report and said what they want to say. That's fine. I don't agree with it, but they have the right to do it, and that's fine. But I don't agree that they were stuck. I don't think they were stuck with a 100% rule. And I've been doing this a long time, and I've represented commissions, and many times in this town, many times, the planning commission has said, we're generally fine with this, and you can deem this an approval. However, we have a comment on X, Y, Z, or we have something that we think you ought to take up, or we think there should be a change in this particular thing, or we think this particular part is not. There's a lot of freedom in that report. Anyway, that's it. I very much appreciate all your patience with going through a lot of work, but,
There's gonna be 2 more public hearings,
yeah,
Gail.
yeah. Well, one of them is going to be their work session, so,
Yeah, but you'll.
yeah. Anyway, I appreciate it, and we'll talk about it after your workshop, and maybe we can shed some light on it. And I was going to say something else. This commission is regulatory. What you do is regulatory. So what you do is, you know, there is some drudgery to it.
Sometimes more than others.
Okay.
Were you gonna set a meeting? Gary, did you wanna set us a meeting?
What's a good date? Probably, no earlier than 2 weeks from now.
My calendar.
How about a football date?
Just ignore him.
2 weeks from today is the 26th, or it could be the following week, too.
I don't know if you need me here, but I'll be unavailable that week of the 24th.
Week of the first week of November is fine.
I'm here.
Gives us more time to, again, read through everything, come up with issues, any other questions you can ask. So the second,
So we're looking,
second, third,
They're looking at November 2nd or
Are
3rd.
you gonna, did you wanna do it on a Wednesday?
doesn't have to be Wednesday.
It doesn't have to be a Wednesday.
Did you say the 26th?
November 2nd.
To November.
November 2nd, it's okay with me. November 2nd. Are you around?
Well,
November 2nd?
am I right that our zoning meeting in November? So we need to do it before that.
Yeah, that's why I say the first week
So-
of November.
So that would be the second. If you do it on a Wednesday, that would be November 2nd. Does that work for people?
Yeah.
Works for me.
It's okay?
7:30?
Sure.
They really want that.
I'm very unreliable at this point, so.
And frankly, I'm not sure how important either one of us for being here. If they have questions, they develop, we have one more public hearing the week after.
Okay. That's part of what we do, okay?
You said so.
It went till midnight?
Pardon?
It went till midnight?
You can wait till midnight.
No, I mean, it went till midnight, that meeting, or 11.
Many.
As long as you review the tapes from last month's public hearing, you can vote. Otherwise,
Put it in the
you
car.
have to be here for everything to vote.
Gotcha.
All right?
So we're looking at
November
November
2nd.
2nd, and, right, and then November 9th is the extension that you need an extension from us.
And which will close.
Right, you'll need to. Okay, but by then you'll have it all. Okay.
Thank you.
Thank you. Okay.
Unfinished business. That's till next month. New business done, any other business? Zoning enforcement officer?
Night shift.
Yeah. So you're not gonna be here on the second or the other, you know?
There are a couple reference documents. I essentially talked about 3 distinct topics. The first being 460 Oldfield Road. Is currently Pomperog Woods. Not gonna read through all of it, but PDD number 6 states no building or structure exempt permit signs and specified in section 10 of the regulation shall extend within less than 100 feet of the street line. Currently, Snyder Civil Construction is proposing to put a canopy over a generator facility that's on the corner of the property. It's on the corner of Heritage Road and Oldfield Road. Yeah, within the 100-foot setback. I referenced the PDD regulation to them on September 28th. An email dated October 5th requesting administrative approval to grant the relief was received. That letter is attached from Snyder Civil. In it, they reference 8 distinct key factors, one of them being the owner is a utility company, the second being the utility use has the need for emergency standby power generator, third, existing generator structure is within the existing fence limits, fourth, facility operators have experienced inclement weather and impacts from rain, snow, and ice, fifth, safety hazard mitigation measure is overhead canopy installation, the sixth is electrical and water infiltration shock risk mitigation. Seventh is premature deterioration and reduced life cycle of generator equipment. And the eighth is a slip and fall hazard mitigation for operational safety. Essentially, they just want to put a cover over it. It doesn't fall within the PDD regulations.
Cover meaning shingles or just like?
So the cover sheet is attached. It's, the entire structure is 16 feet in length, 13 feet wide, and approximately 11 feet, 7 inches tall at its peak.
Be a big generator.
The entire fenced-in corral is 25 by 25.
Oh, so it's pretty big. Yeah.
That's bigger than the existing.
Wait a minute, it's fenced in now?
It's currently, the generator site is fenced in. They want to
just
put a
wanna put a
canopy
cover over it.
within
It's
the
a solid
fence.
fence? Because I don't recall ever seeing it. I know there's a generator there. but I don't recall-
Yeah, I know it's there. I can hear it sometimes.
It's tucked in, yes, sir.
Huh?
You gotta hear it.
I mean, I can hear it sometimes. So, yeah, that's how, I live in the corner right there.
Right. All right, can you see it?
Would you
If
like
you
it?
really look,
Would you like a cover?
I don't think it'll bother us.
Good.
Yeah,
I
mean,
wanted to
I
bring
can
this-
understand them wanting to cover it.
Exactly, yes.
yeah.
And it made perfect sense. I wanted to bring it before the commission just to get the reference instead of, having to go through ZBA approval after a rejection, so.
I don't see any reason why we should approve.
Okay.
Do you need a formal approval from us?
That
I
would,
guess it'd be best.
that would be great, yeah.
I move that Pomfret Woods be allowed to put a permanent cover over their generator.
All those in favor?
Aye.
Aye.
Opposed?
Now you come and vote?
Yeah. I'm the night shift, I told you, yeah.
Moving right along, this is just a reference. Currently, Joe Lasky of Lasky Tree Service is looking to lease the old Chainsaws Unlimited building at 586 Main Street South. Couple different, there's a couple different options floating around, but in speaking with Gary, one of his options that he floated was selling firewood from his tree service business. Per regulation, Schedule A, Section D1C for Zone B2B, that's the registered vehicle. Schedule A, Section C19, which states that lumber and building materials is prohibited in the zone. Just having a conversation and getting, instead of looking at the language so strictly wood, building, lumber, it was determined that firewood and lumber are distinctly different, and that particular use wouldn't be restricted based on this regulation, whether or not he chooses to go through with leasing and operating the facility.
So
is
he wants to lease that building and store firewood to sell to people out of
He
that
wants to
building?
sell it out of the back. His entire plan is to operate the lower level for
Yeah.
this, and he wants his partner to actually operate some retail operation,
But he
maybe.
didn't say what it was gonna be.
coffee shop. It's all very
So he's gonna
speculative
have-
at this point.
He's gonna have a detail, not a detailed plan, but some sort of plan.
Exactly, that's the movement
If I
going
remember
forward.
correctly, Chainsaws Unlimited had a pile of wooden pallets there. All the time.
Yes, yes.
This can't be any worse. And if,
It might be staffed
if he's
better,
selling
think
the
of it that way.
firewood in the back down below, then you're not really gonna see it.
No, it's down.
So I don't see any, I mean, he's gonna have to,
Coffee shop upstairs?
Potentially, yeah, and, you know, in talking with them,
Make a fire and have coffee, a camp out.
There you go. A bonfire.
there might be a need for it, you never know.
If there's a coffee shop going in there, there probably would be some aesthetic improvements.
Ideally, ideally.
It's only can go up.
can only get better.
That's been discussed distinctly, you know, bringing up the community in that area. It's a prominent site, so seeing that uplifted would be hugely beneficial. Chainsaws Unlimited operated for almost 30 years, but, you know, to see it improve would be.
Is the
very
parking,
beneficial.
they're gonna be able to handle, is there enough parking for, like, to handle that?
So looking over,
A coffee shop
I
with the
would
wood
say
below.
yes, up on top.
Yeah.
I mean, they had all that.
Yeah, true.
They got that whole,
Over there and a
yeah.
bunch of things.
looking through old plans from, I'm not kidding, the 70s, they were permitted previously for 27 parking spaces. That included the area that Gary just previously mentioned. It
Okay.
also included parking in the back area.
We're bigger.
Yeah.
You're not wrong, they
How
absolutely
many
were.
you get 30 parking spaces now?
We'll put a couple compact ones in there, yeah, some EV charging, but that's a whole other thing. So that's essentially ties that one in. Lastly, just to bring to the commission's attention, I've only been doing this for a month, as you all know. However, thank you so much. In that month, I've had a number of inquiries related to short-term rentals, or STRs. This includes things like Airbnb and VRBO, which is vacation rental by owner. You know, with ADUs becoming so popular and Southbury recently adopting them, the potential for a person to, you know, have a new construction or retrofit a garage to become an ADU, and then suddenly have their kid go off to college in any instance, and then suddenly want to operate that as a potential rental property, is becoming pretty popular, and I can only see becoming more popular. With Southbury going through the regulation refresh, I thought it might be pertinent for the commission to consider including language, either permitting or restricting the use of STRs in Southbury, and having that clearly defined moving forward.
Our refresh is really, we're not changing the zoning.
Or adding,
regulations.
correct, yes.
We are clarifying
Right.
sections
Yes.
of the zoning. So
That would be a whole separate thing to go do.
to
Correct,
change
yes.
the actual regulation is going to require a public hearing process, so it's a more drawn out.
Fair enough,
process.
yes. As of
That
right
doesn't
now,
mean that-
yeah, it wouldn't be beneficial potentially. Right now, bed and breakfast regulations are the only thing we really have pertaining to any short-term renting of anything, and that can only happen within the historic district and under strict circumstances. I can already pretty much guarantee that there are people out there currently doing short-term rentals,
You know that
It's
it's
already
already
happening.
happening, because you can't monitor and control it.
especially in areas, you know, like Lower Fish Rock, where, you know, people have these little homes that they might not be at year-round, and they want to fill it and make a profit, and it's very easy to hop online and create an account, and then suddenly have your house rented because you put a padlock on it and someone cleans it weekly.
Isn't it also you can determine who's doing what by going online and looking for it?
You're not wrong.
Go to Airbnb into Southbury.
Exactly, right. So with clearly defined regulations, that would even be easier for me moving forward to determine who's potentially not permitted or working outside of the regulations.
Your
And
job just got a lot bigger.
happy to do it, you know what I mean? Especially if I'm the one that kicked it off. That's my baby. Like, no, I actually know very much about this one. Yeah, exactly. The regulations are included. We don't need to read through anymore, but that is my report for you all.
All right.
Short and sweet, that was good. Oh, the public, oh, for next month?
Yes.
I move that we can put that part in.
Right. Thank you for last meeting, last month.
Too bad.
All right,
So I move that we accept the minutes from the September 14th meeting.
okay, with.
Oh, with the
Correction that
one
they've come in
correction
late.
that, no, we got a second our,
Bills? No bills.
No.
Any other business?
no.
Got our motion to adjourn.
I move that we adjourn.